My name's Vanessa Munro, and like a lot of colleagues here at Warwick, I suppose you would describe my work as socio-legal. I'm particularly interested in gender analysis, and especially in the way in which law sort of polices the boundaries of women's ability to consent, especially around their bodies. So that dates right back to my PhD, was about rape and sexual violence, but also about enforced cesarean section operations and about the ways in which the law does or doesn't recognise women's choices around their bodies. And that's really, I suppose, a theme that goes through all of the work that I've done since then. So I do a lot of work around rape and sexual assault, both looking at the laws and how they're interpreted, but also kind of assessments about what makes for a credible claim in those contexts. As far as the jury research went, I think one of the things that across the 3 different studies that I've done, and I'm currently involved in another jury project, they indicated, I think, first and foremost, that juries do struggle to interpret the legal standards around consent, that they do inevitably rely on their own experiences as part of how they interpret, and that that's actually part of what the law requires them to do. So in a sense that's legitimate, but that oftentimes those experiences and those assumptions are based on misconceptions about how a victim, a genuine victim, would respond. The assumption that there will always be signs of injury and resistance in rape cases. One of the studies that we looked at, in fact, was about how we can shift some of those assumptions. So we looked at judicial instructions and expert evidence to jurors to see if that, by giving them that information, it made them think a bit differently in their deliberations. I think there's much more work to be done looking at understanding what happens behind the closed doors of the jury room and why individual verdicts emerge, because it's not just about the case and the legal test, it's also about the dynamics in the room, whether there are particularly kind of dominant people as part of that discussion. But I think it yielded some fresh insight into what does go on there, which at the moment is a little bit of a kind of closed box in the criminal justice process, and yet such a hugely important part of that process. What makes me pick the subject areas that I pick is driven really by the idea that you can make improvements in a much more concrete way. And one of the things which came out of some of the research on juries, for example, was that we were involved in a process to develop extended judicial instructions, which went into the guidance that judges in England and Wales give, and also something similar in Scotland, so that in cases, for example, where a rape complainant delays reporting, there is now an instruction which is recommended that judges should consider using, which will go to the jury. And so our research suggested that that had a positive impact on jurors' discussions. So, you know, to my mind, that plays a role in helping to increase the likelihood of justice for that individual complainant, and also in turn, because that has a sort of cycle effect, if you see more rape complainants coming forward and securing justice in those cases, you will then create more confidence in a system that more people will also begin to report. At the moment, I'm involved in a couple of projects I'm super excited about, actually. One of them is the Scottish Feminist Judgments Project. And the idea really is that in all of these projects, what you're trying to do is take a case and say, look, with the resources that were at the judge's disposal, they could have done something different. So whether that's that they would have reached a different outcome, or whether that's they would have reached the same outcome, but they would have used different material, they would have presented the narrative in a different way, they would have used different reasoning, which would have been more kind of feminist relevant. So it's, in a sense, it's a kind of intellectual exercise to show the choices that lie behind judges' decisions and the political basis of those choices from a gender perspective. But alongside that, one of the things that I've really loved about this project is we've created a kind of artistic strand to the project as well, because we didn't want it to just be about the written judgments. So we have a creative coordinator who's come on board, and we have a group of artists. So we have poets, playwright, an illustrator, a songwriter, and they're all creating pieces of artwork inspired either by individual cases in the project or by the project itself. I think, and this sounds really cheesy, but actually I don't care. I think probably my daughter. So she's 4 just now, and I do spend quite a bit of time trying to just, actually not just my daughter, my son as well, who's 6. And again, I spend quite a lot of time trying to just, challenge those messages that they get over and over again about what gendered roles look like and gendered expectations. And I think that as obviously a lot of the work I do is quite sensitive, so there will be a time and a place at which you talk to them about some of these things, but already I talk to them a lot about it's important that people have a kind of bubble, a personal space bubble, and we have to respect one another's bubbles, and we don't encroach on someone's bubble unless we're sure that's okay, and I think even from that early stage that's very much grounded in what I'm interested in, how I think about the world and what I want them to carry through into adulthood.